Good. Somebody sent me.
Welcome back to the live stream. I think we are live playing around with the software, but welcome one and all to those that are waiting. And I am joined once again for this live stream by our Alan Robertshaw. Good afternoon to you, Al. How are you doing?
Good afternoon. I'm doing very well, although I'm sweltering, which is why I'm hiding out in a room where I store clothes and things because it's slightly.
Yeah, we can't handle the heat, can we, in the UK here, can we? But good morning from Canada. You probably, depending on where you are, probably can handle the heat, and likewise Florida. Hello from Florida as well, and hello to my dear wife Easy Chinese cooking in the room, and from Vegas. You can certainly handle the heat. So no, we don't always we don't always handle the heat and everything else too well, do we? Someone's saying no volume. I think there is volume. My thing's going up and down. So if no one can hear me, then let us know. But I'm sure it's okay. Hopefully it's okay. So there's a few things to talk to you about in this video. Not just that which features on the thumbnail. It's got to be something to bring you in to the video on the thumbnail, of course. That's the way YouTube works. But there's plenty more. You can be held accountable for what you say on Twitter. That's about right, isn't it, Al? That's about the stretch of it.
We've had a really nice case yesterday. It was a Court of Appeal judgment that all arises out of a little bit of a Twitter spat. But there's a couple of reasons to talk about it. First of all, it's very, very useful for how the courts are looking at, online social media defamation. But more importantly, you might remember back to our sort of video about the commenting on somebody's driving, and we raised the point that although the statement could have been read as an accusation of something what we call chase one, relatively serious, you have definitely done this, we were making the point that that would be neutered by the fact that people could watch the video themselves.
Yes.
But this arose in this case. It was to do with Rachel Riley, the ex-Countdown sort of maths person. And just to give you a little bit of background, effectively, a chap called Owen Jones, a journalist, who had commented about somebody had thrown an egg at Jeremy Corbyn and said that was terrible. And then Rachel Riley, who's not a big fan of Jeremy Corbyn, I think that's safe to say, I think that's defamatory, she put a previous tweet of Owen Jones where he'd said it was okay to egg Nick Griffiths. So, it's okay to egg Nazis. And she just retweeted it with good advice, smiley face. Now, what did that tweet mean? This is what's interesting. Somebody commented, and here's the thing. They commented and said Rachel Riley is inciting serious violence against Jeremy Corbyn and comparing him to a Nazi. Now, Rachel Riley sued over that, and the defense was, well, I was just referring to this tweet. But if Dan can bring up the relevant bit, what's interesting is the judge said yes, but
let me just
anybody seeing the original tweet could have seen and said, we looked at this, the comments where a lot of people were going, no, Rachel Riley was just being sarcastic. Other people were saying, no, it was a serious accusation. He said, but people were expressing their own opinions on that tweet, so that was fine. What I said is, had you have just screenshotted the tweet you were commenting on, so people could have looked at it and gone, either I agree with her or no, she's talking nonsense, that would have been the end of it. But she actually lost the defamation case. Now, interestingly, they knocked the damages down to 10,000 because they said effectively Rachel Riley was deliberately provoking people a little bit. But that wasn't a complete defence, the mere fact that somebody wound somebody up. But this just goes to show that it's the point we were making in that, the other live stream about the commentary. If you are going to comment on something, make sure that people can see what you're commenting on and form their own views. And that gives you a lot of protection, because even if you say something that is defamatory or unjustifiable, the mere fact that somebody else can see it and say, well, yeah, I can take that view myself, you're clearly talking nonsense, that's fine. And that is an absolute complete defence. And I just love the way that the court addressed it very quickly, where they said, simple expedient. And that could have saved all the damages and probably hundreds of thousands of pounds in legal costs.
And this is a fundamental point of principle, really, isn't it? And so just to make sure that this point is not lost on anybody. So this essentially a bit of a Twitter spat, Twitter comment. could be taken, well, it could be taken to mean a variety of different things, but it was what was reasonably inferred by a person reading it to mean that somebody should be violently attacked, and that because of this comment that someone shouldn't be listened to, and so on. So a statement made with a reasonable interpretation by somebody may well then be defamatory. But the point of this is, if somebody is able to see the original and make their own determination, come to their own conclusion and think, well, actually, no, I don't think it means that, and I don't agree with you. As I've said on this channel before, you don't have to agree with what we say. There's reason and there's method in the madness. You don't have to agree with what we say, just as we did the Ashley Neal video. We made a point of showing you the video and to say, well, if we weren't even really commenting on the driving. I did that in a different video, but again showed you the video, and you've got your own opportunity to make a view of it. And because of that, you've got this distinction between just what somebody says, which other people could rely on, and making your own conclusion, your own judgment. That means anybody, right, Al? That means anybody making any disparaging comment on Twitter, which does go on to have a serious harm effect per the defamation rules, is potentially liable to a defamation, even for one single tweet. That's about right, isn't it? Unless
one tweet. And if you scroll down to the bottom of the judgment, they actually the judge actually took the single exclusion. So this was the tweet that it all came about, and like the offending tweet was somebody commenting and saying, but without referencing this tweet, Rachel Riley is encouraging people to violently attack Jeremy Corbyn.
So this one was known as the good advice tweet, or the GAT, if anybody looks this up.
Yes, they call it in the judgment, yes. And that was it. I'm sorry, Dan.
Yeah, no, I was just going to say it. And so that's really it. That was a very simple tweet that people could then take to mean something, and without the context of the original, they take it as it is, and so they're left without that opportunity to form their own views.
Yeah. So as I was saying, if somebody was to say that was clear, I saw somebody do some clearly deliberately bad driving, without showing you the video, the context. Well, that's clearly a what we call chase one level statement. This person is definitely guilty. But by being able to see the video and make your own assessment, it takes the sting out of it, because people can go, that's just clearly wrong. You can't assume that. And it turns what is effectively a statement of fact into a statement of opinion, even though it's expressed as a fact. They also do go quite into the public interest defence and the opinion defence. And what's very interesting is, what we've always said is that the test for opinion as a defence in defamation is that it genuinely is an opinion, that it's based on facts that you refer to, and that it's an opinion that somebody else could reasonably hold on those facts. Now, what was interesting here is they just clarified, I think we'd always understood this, but they always clarified, they said, those facts themselves have to be true. Because they said, we accept that that was your opinion. We accept that you based it on the facts, i.e. the original tweet. But the fact is, the original tweet, that those facts weren't justifiable. It wasn't a statement of fact. So, for instance, to give another example, if, for instance, you hear about some dodgy doings in your local council, contracts or something, the usual thing that you get a lot of social media defamation on this. And then they say, I think this clearly shows all my local councillors are corrupt and dodgy, and it shouldn't be allowed. Then when the audit, they sue you, say, well, no, that's just based on the fact that there's all these reports about these contracts. But then there is an audit, or somebody comes in and clears the person and says, actually, no, these facts, these aren't the facts. Then all of a sudden that negates your opinion because it wasn't based on true facts. And this actually crops up in that Banks and Codwaller thing. And it's what happens, and this is going to appeal, because it's what happens if the facts change. And what had happened there is, she said, effectively, there are grounds for investigating this person's business dealings. because I think they are corrupt and dodgy, and there's something not right about them. Now, the fact of the matter is, at the time, he was under investigation. So they said, well, there's no problem there. There's absolutely no problem because you're commenting on an investigation. However, during the proceedings, during the currency of the statement, the investigation completely cleared this guy and said, we've audited him, we've checked everything, he's completely kosher. And what they said then is, do you have a duty then to go back and correct and say, actually, further to my previous statement, bear in mind this was an online article and it was still up. They're saying, there was videos. They say, should she have released something afterwards? And they said, you can't really do anything about the videos because they're in the past, but the stuff you've left up, should you have gone back and said, actually, further update, just to let everybody know he's been cleared? And that would probably have been enough. You needn't have rewritten the entire article, but just to say, this is what I wrote in the past. And it's this idea that you put the information out there so people can make their own views. Because by saying he has been investigated and cleared, even if she'd written, I think he's still dodgy, people would have gone, well, I don't see how that's fair to say that. So that's the irony. If people say, I don't think that's fair, which is one of the arguably the defamation tests, but people can make that judgment themselves. The court say, we don't need to get involved because all we're doing, if you remember all this, think like, and they said this in that, they said this is a case where people need to think like ordinary people who read Twitter and not lawyers who will overanalyze this to death. Because ironically, they said, the definition of violent assault to a lawyer would include throwing an egg. Because assault is just the fear or use of force, and the violence is a very low control.
But they said low bar, really. I mean, some people think that's just throwing an egg. Well, where do you draw the line? It's fear of harm, as you say. It doesn't even have to be physical contact. You could be someone threatening to throw an egg would count.
Yeah, exactly. But that's as a matter of law. But they said lawyers would think that. But normal, regular humans would just go, throwing an egg's not serious violence. That's just throwing an egg. And that was very interesting how they, did address that point that you just look. And again, they did all this because part of the thing was she'd sent an earlier tweet that did effectively. She had commented separately under the original good advice tweet and said, I think you are inciting violence. Rachel Riley didn't sue over that one. I mean, there is some dispute as to whether she even saw it, but she didn't sue on that one. And the court said she wouldn't have been able to sue on that because that was just a comment and people could have seen what she was commenting on and gone, that's all nonsense. You can't make that argument. Or said, some people might say you can make that argument. But the fact is that all this, it's the single meaning rule, what would people most likely think of it, said that doesn't come into play until we get into court. If it's all being thrashed out on the internet, so long as there are reasonable meanings that people can draw, they said the test for whether they're reasonable meanings is there's loads of people drawing that conclusion. And they actually said, we've looked at what was going on Twitter, and it was every opinion was coming. People had agreed with her, people disagreed with her, people had their own third sort of way opinion. They said that's fine because we want to encourage free speech and public debate, but so long as people are informed of the facts. And it was the isolated.
And there's an interesting question because. To what extent is a member of the public required to go and investigate the facts? That's an interesting question because if a member of the public were to come across a statement, a publication, a piece of media, which we're going to come back to in a minute, which is the main sort of pull-in on the thumbnail for this video. If someone sees something in the media, reads something in the media, and then makes a comment on it, opines on it, I think this is X, Y, Z, or I think he or she is whatever, based on what they've read. To what extent do they have to go and investigate the facts that they are true before they give that opinion for everybody to read? Because the whole point of this is it went viral, right? Was it 15 million times it was seen or something like that? 15 million impressions. And, if 2 or 3 people see it, then big deal. But if 15 million people see it, then there's a much...
Well, the courts do investigate because there's 2 aspects to this. Is how much research should the person doing the statement do? And there used to be this old Reynolds defence, they called it, which was here's effectively a checklist of things to do. Have 2 sources. Corroborate your sources. Give the other side an opportunity to comment. Do a bit of research. It was like that went, and it became a lot easier, supposedly, to do the public interest defence. There's not quite as heavy a burden. And the courts, despite saying, do not try to import Reynolds back in by the back door, it's not a checklist. There's loads of cases where they've gone, it's not a checklist. However, it's quite handy to refer to, so let's use it as a checklist. But you don't if a matter's urgent, you don't have to contact the other side. If you're defaming a public figure, well, are they even going to get back to you if you sort of say, hello, Mr. or Mrs. Famous Person, I'm thinking about saying this about you, any comment? That probably wouldn't be worthwhile. So you've got, how much research does the person doing the statement have to do? And that is very much on a case-by-case basis, and they might expect a lot more from sort of, the Washington Post, Woodward and Bernstein, as they might from somebody just tweeting away, some member of the public or citizen journalist just tweeting away. Although, like, one thing they have done is the courts have said there is no distinction now between, professional journalists and citizen journalists and traditional media, legacy media, whatever you want to call it, and new media. They said, the same freedoms we give to the editor of the Times, we give to the person blogging to 4 people in their back bedroom.
And vice versa. I mean, the same sort of responsibilities as well, because just because it's the Times or whoever doesn't mean that one person, as you say, one person in the bedroom can't have the same effect if that thing goes viral. I mean, tweets and videos and whatever can garner just as many views and comments and impressions as any newspaper. I was watching, I won't name who, but I was watching, actually I wasn't watching, I happened to notice that one of the news outlets went live on something earlier today and had a few hundred people watching. Well, we have nearly 400 people watching now, and it's a Friday, it's a quiet day. It's a bit of a slow news day, I suppose, but yeah, I mean, you don't have to be this huge media mogul outlet to get that sort of audience, but there it is. So now we thought this was very interesting because you can be held and taken to task just for a tweet, a very short, just a couple of words, literally a couple of words in this case. It was a couple of word tweet that some people could take, and obviously it was taken further, but that was that. We might circle back to that. But for those that have been sort of probably patiently waiting for the subject matter of the thumbnail of the video, the media is obsessed with nuddy photos. Obviously, YouTube will probably screen certain words, possibly already has, but anyway, so this was Heard's lawyer's complaint, if you will, within what was this? It was a motion in limine, wasn't it? I believe it was one of the motions in limine. Motions in limine are, for those in England and Wales, are like an application, if you're familiar with such things, like an application to exclude evidence or something like that. So this was a complaint about alleging that Depp was trying to get these photographs into evidence. And this is, of course, the line that lots of the media have been quoting to say that he tried to get these photos into evidence, which, Al, as you put it just recently on Twitter, which reminded me of this to look at today, it was a gross mischaracterization of what actually happened, which is a very polite way of saying cherry picking the evidence to suit the headlines. So this is the bit that Heard's lawyers
I just want to sort of say why I did that, because people really notice I made a thing of not commenting too much on the merits of the case, because I keep coming back to this. It's not my job. It's that, in that case, it was the jury who were in a much better position. They watched all 122 hours of the trial and arguments. I certainly didn't. I watched a lot of it. And also, I got to see all the stuff they didn't, like, the motions, because, when they were out of the room. So, but it's this thing about, and it ties in what we've just been saying about, everybody's entitled to their own opinion, but they're not entitled to their own facts. And I'm not suggesting necessarily, legacy media is is out to do anything, deliberately here. Although, of course, legacy media does have a vested interest in supporting defamation defendants because they're so often defamation defendants themselves. So they need to in the public get an idea that defamation should be hard to bring. They've got to push the free speech, freedom of the press arguments, understandably, but they've also got to get a perception that whenever a jury finds for a claimant and finds somebody's been defamed, they've got it wrong. And juries aren't really suited for this task because they need to be able to point when they get done themselves and go, oh, well, with all respect to the jury, they're not professionals in assessing, this sort of thing. But it's just to get out there. And, our whole mission here, if we have one, is demystifying the law and trying to explain to you what's going on. I mean, other people have done that really, really, really well. As people, it isn't just us doing it. But if people want to debate about, trials, not just that trial, but all other ones, or what's going on, and we're going to have this with upcoming trials. Everybody's an expert now on probable cause because of the FBI warrant against Trump.
Yeah.
People need to know what the actual legal facts are. First of all, what the law is and what the law actually says, not what people guess it says, and also what the actual facts of the case were. Now, we can certainly try to assist with the actual law, and also just doing things like this. It's actually, here's what it actually says, draw your own conclusions. But this is before people are saying, oh, they did this and they did that. Well, actually, did they? Because if you actually look, and I'm sure Dan's going to bring up the response in a moment to that, where they're saying, you're trying to do this. And of course, the response is, and Dan's going to bring it up, but nobody's reporting on the response.
Yeah, so let's do that in turn. So this was the complaint. For example, pictures or comments about her doing this or that would be highly distracting and unfairly prejudicial to the extent that they portray her badly, and second, and so on and so forth. So this was a complaint to say that he's trying to bring these photographs in and it's going to distract the jury, be unfairly prejudicial. We've had this discussion of, something being more prejudicial than probative. Probative being useful in looking to what really happened. Prejudicial meaning just going to essentially make someone believe something without any basis or fact. The response to this was quite stark, quite clear. And this is the bit that, as Al just said, this is the bit that the media really, from what I've seen, has left out, for legal reasons, of course. Mr. Depp does not currently anticipate introducing into evidence these pictures, though it's possible to envision a scenario in which such photographs might become very relevant in the context of the case, for instance, to show a lack of visible injuries, as a result of which the court should not finally resolve the issue in limine. So this was the truth of it. This was, well, no, we're not planning to introduce them, although they might show that she wasn't injured when she says she was, if the date stamps match up. And actually, these, as unflattering as they might be, or flattering in some people's eyes, of course, they might show a lack of injuries, which goes to an issue in the case, because that was a very real issue in the case. Yeah.
And no lawyer is going to, in advance, say, we completely waive the right to put in relevant evidence, because then you're leading to somebody say, actually, there are loads of photographs of me covered in bruises. And then say, well, actually, they don't show that. No, you've agreed not to put those in. So it would be a very negligent lawyer. And like I say, a lot of what lawyers do isn't to be nasty or bullying. It's we have a duty to our clients, and also we don't want to get sued.
And,
so
and there's a strategy involved there. Absolutely. I mean, Al will sort of no doubt echo what I'm about to say, which is that more than once that I can even possibly remember, I've given advice that someone doesn't want to follow. Says, no, I just want to do this. And I've said, well, you shouldn't do that, or you can't do that, or it'd be bad to do that, or it would be damaging to do that, or costly to do that, or risky to do that, or you're going to lose, or whatever. And they still want to do it. But sometimes we have a duty, like for example, if someone said, I want you to write this to that party, I want you to threaten them with X, Y, and Z. And I will say, well, first of all, the law doesn't support you, the facts don't support you, it's going to be risky, this will come before the court and, fly back at you with costs, and in any event, if it's a threat, I'm not doing it because it would be unprofessional to do it, and I can't do it. And so you get into this back and forth. And so here we have this whole issue with photographs. As Al just said, just to clarify the point, because I think it's an excellent point. I think it's a really, really valid point. If they were not to say this and say, we might want to bring these photos in at some stage if they're relevant, if they said, all right, fine, we won't bring them in, we'll just never bring them in, then later on, in case the point was lost, they could have said, yeah, there's 1,000 photographs with injuries, but you've agreed not to have them in evidence, but trust us, they're there. Then what do you do if you've agreed not to have them in? So it would be bad advice not to argue that they could go in at some point. But as this we just showed, let's go bring it up again. He does not currently anticipate introducing into evidence these photographs, but it's possible that they could be introduced in the context of the case to show a lack of visible injuries. And that's the difference. And that's probably, I suspect, what is not very well reported in at least the headlines that I've read.
There's a case recently on a completely different thing. It was a really boring financial case about a property dispute. But one of the issues with there was a letter, and they were saying, no, we had always attempted to settle this, and we were the nice people trying to resolve it. And they sent a letter that had, it was a without prejudice letter with, here's we want to solve it. At the bottom, the last paragraph said, our client does, of course, reserve the right to issue proceedings. And they said, see, that was a threat. They have to sue us. And the court said, no, they have to do that because otherwise it's a promissory estoppel situation arises where if you can't settle this amicably, and they then have to bring proceedings, you can turn around and say, no, you've waived the right to sue us. So you could have just, as soon as that letter came, you said, yes, we accept your proposal, do the mediation, say, no, go away, we're not paying you anything. And the other side wouldn't be able to sue. And that was the whole thing. The judge said that was clearly just a CYA line stuck at the end of what was clearly an attempt to settle this in good faith.
And that's just normal and par for the course. And in fact, even I've had someone argue, there's a lawyer actually argue that the throwaway line towards the end to what was originally the litigant in person, i.e. someone without a lawyer, almost a throwaway line, not a throwaway line, but a throw it in for good measure line at the end to say, if any of this is unclear, we strongly suggest you seek formal legal advice. That's a lawyer's way of saying, we are not going to take advantage of you because you don't understand the law. So if you don't understand the law, we suggest that you go to someone that can help you to understand the law so that you're not disadvantaged. It's not a threat. It's not someone waving some kind of hammer over you to say, we're the lawyer, you're not. So, you go and seek legal advice because we're the lawyer. That's not what it is. It's quite the reverse, in fact. It's as a lawyer against a party who is unrepresented, we have, albeit limited, but we have a limited duty to assist the unrepresented party and the court in assisting the unrepresented party. It's a limited duty. We're not going to go and fight their corner, but we have that limited duty to not, certainly not to take advantage. And so when people respond to letters like that, which says, if we don't hear from you, we may file proceedings without further notice to you, it is a warning, but it's not a threat, as Al just said.
Yeah. We'll have to, at some stage, we'll have to chat about blackmail, because that's very interesting, because people do say, when does it cross the line? I've got a case on the well, I can't really discuss it, but it's when does legitimate legal cross the line? And this all ties back into the use of the law. And to get back to defamation, we've got all this anti-SLAPP coming through at the moment. Yes. SLAPP are strategic litigation against public participation. And what that basically means is people using the law, not because they think they've got a meritorious case, but to use the risk and expense and threat and inconvenience of legal proceedings merely to shut somebody up who they disagree with or who's saying something they don't want people to hear, whether it's true or not.
Yeah.
I mean, this is something, obviously, with the animal rights stuff, that's, as I said before, a lot of my work is effectively people using the threat of defamation or bringing defamation proceedings to stop. I do a lot of stuff for people who do the undercover investigations, the filming on farms and abattoirs and things like that. And, that gets massive publicity in all the newspapers. But as you can imagine, the relevant companies, I mean, ironically, the one thing that's always really hard to prove in defamation is serious harm, because for a company it has to be serious financial harm. But as we said before, it's really easy for those companies because they can literally say, here's a list of cancelled contracts and how much we would have got for it.
Yeah.
So that's why they have
to supported by correspondence to say, we've seen this about you, therefore we're cancelling the contract. That's just
but it's all back to this thing which ties into all these high-profile celebrity cases. It's not about the litigation. The litigation is a tool as part of reputation management. They need to get a narrative out there. And of course, because you can comment about legal proceedings without any fear of being sued, because it attracts privilege, they can just publicise, say, our defence is, this is all true and that's a lie and they were never there, whatever. And even if the defence is completely untrue, it doesn't matter. It might matter legally, but it doesn't matter publicly, because people will just read that and go, oh, okay, well, that's the facts of the matter. They're clearly not as evil as I thought. And it doesn't matter. And without going into too much as to whether or not these things get to trial, because it's all about getting the publicity out there. But the fact of the matter is, and I'll tell you now, actually, because this is a slap. We could win those cases easily because we just go, here's the videos. However, and this is going to tie into costs, which we also want to talk about, the rule is loser pays, winners costs. However, you never get your full costs. On what called a standard basis, you're looking to get 67% of your costs. And defamation claims are very expensive. And unless we're going to work with pro bono, and we do a lot of that, but, at the end of the day, we have to eat.
And the same goes with interest as well. I mean, interest is always, almost always pleaded at 8%, but almost always you don't get 8% unless there's been really bad behaviour during the litigation. I've got 8% before on a claim. But it's normally 2%. 2% is probably about average.
I got knocked back because the judge said it shouldn't be more advantageous being sued than sticking in a building society. I'm going to give you 2%.
Yeah, exactly.
Yeah, but to get back this cost thing, the successful claimant can be left with like a 30-40 grand shortfall to make up themselves. So even though it's not viable to do that. And, I keep saying, loads of cases settle, and one of the reasons is people go, we can't afford to fight this even if we're going to win. And if the other side come in and say, we'll throw the towel in, we will now discontinue. The rules are, when people discontinue, if you issue a notice of discontinuance, you're agreeing to pay the other side's costs. But again, we had one.
We had one recently, actually. It was a totally frivolous and vexatious claim, and not before a huge amount was spent defending it. Then they just said, actually, we're discontinuing it. We essentially the reading between the lines of what was said was they just couldn't be bothered anymore, because they were doing it themselves, but it was taking a lot of time. And so the way that it was worded, it sounded, if you read it, you would probably infer that it just meant that they just couldn't be bothered anymore. Now forget it. And what they hadn't obviously anticipated was like, well, you're now by default, really, you've got to pay the costs. But initially, the court had made this order to not resolve this, which was a bit odd, because the natural follow-up was, why would the court rule that? Because that's not the standard rule. So there was actually a follow-up application to say, no, you need to address this issue of costs. There's lots of costs been spent here. So that went back to court. I need to bring up one of my cases recently. I've got a lovely one where it was one of my a backdoor attempt to introduce animal personhood. I mean, it was technically, and I can talk about this because there's actually an article in the media about it, because clients were very happy to publicise it. It was actually just a negligence claim against a vet about a poor dog. And I was trying to sneak in. Also, we want to bring a claim on behalf of the dog, not just the owners. Because the trouble is, in law, it's just a contract claim. It's a breach of contract claim.
and everything. But the funny thing is, I ran this. The judgment contains the phrase, Mr. Robert Shaw seeks to argue a cause of action unknown to English law. So perhaps unsurprisingly, we lost on that point. But what was really good is the other side came and said, well, we'll just have all our costs now then, thank you, because you've said this is like we've won and this is a case that should never be. And the judge said, no, I can see why they brought it. No orders to costs. That was great. That's really, really, really sweet of him. I mean, He did say a very interesting thing because, and I'll say the dog's name because it's all public. The judge said this lovely thing where he said that, I don't want to sound cold here, but he said, to the claimant, Bailey was a family member, a much loved and dearly missed family member. But as far as the law's concerned, he was just a dishwasher. Animals are property, and that's a great quote he gave us. I mean, the judge was lovely. He actually brought his own dog into court with him while we had the trial, and he was, he was very fair in his judgment, and he was completely correct on the law. Because it's quite funny because I'm criticising people using the law for an improper purpose. Using the law not to win, but to try and make a point. But I spent all my time with my colleagues pushing animal personhood points. Although, in fairness, that's a genuine thing because one day we will get there. We had a case in New York recently, and we lost 5-2. I say we, I had a very minor part in it, but the great people of the Non-Human Rights Project lost 5-2 on getting personhood for an elephant. But two penal court judges agreed with us. And there's always this idea that the dissenting judgments eventually become the actual law. So that's why we.
It's a very interesting concept, isn't it? Because I've read one or two comments saying my mic is not loud enough. I've just adjusted because I've been tidying the room up today, but hopefully that's better. But it's an interesting concept where what ultimately is the view, the least popular view, then becomes the law later on. I find that quite interesting.
Absolutely. I'm just trying to bring up a quote that I use quite a lot. If you just fill the space for a second, Dan, while I try and find Paul Chambers' website.
Thank you to Dorothy, your comment here. We very much enjoy bringing the law to you in hopefully what is a very digestible way, because when I started this channel during the pandemic, obviously had a bit more time on my hands because a lot of cases were cancelled and so on, and so I just thought bring this channel to lots of people, and now Al is more echo now. I think that's probably because of my microphone. So I don't like using echo cancellation because it sort of lowers the quality, but maybe I'll bring this away from the speakers. But no, hopefully that
lowering the quality, you wouldn't have me on.
Very funny. I think that's I think that's a comment for you, Al. That one there. Hopefully. Hopefully that's
my lovely cup, because I've just got one cup that don't get me wrong, I am quite clean and tidy normally, but I've got my one emergency coffee cup that just lives next to the emergency kettle next to the office, which is quite a long way away from the sink. I mean, people have pointed out and said when you fill the kettle up, you could actually take your cup and wash it. It's like,
So here's I'm just seeing me going into the red. I think I've messed my audio up, but hopefully this is better. Do let me know in the comments if I'm too loud or too quiet. Let me bring this back on. They disappear after a while. What's the opinion on claimants that might not follow logic to prove a point, i.e. they go to court to prove a point, namely that the case was to win over the children? Well, as we often say, going to court, you're asking the court to make a decision, and then you have to provide both the factual matrix and the evidence, which a lot of people mix up because they're not the same thing. The factual matrix is this is what happened in what we call the facts upon which you rely, and then back it up with evidence. So the facts might be somebody reversed into my car, dented it, scratched it, whatever, drove off, and didn't contact me about it, which is a failure to stop. That's the factual matrix. Those are the facts that I rely. But the evidence might be CCTV, it might be a witness, it might merely be the fact that there is a scratch on the car, and there's something else ties the other vehicle to it, embedded paint, or somebody saw it, whatever it might be. That's the evidence, and you bring the evidence later. But you've got both things. So when you tie all of that together, what's my opinion on it? Well, it depends what they are asking the court to decide on. And so if you go to court with a fact-find hearing, i.e. you're asking the court to make a finding of fact on certain things, so there might be 3 or 4 different things you're asking the court to find. It's very often allegations. This happened, I say this happened, and you say what you say happened, and then you provide the evidence as to what happened. And if they all tie together and the court agrees with you, the court will make a finding of fact. Whether that can then be used in something else is another matter. And Al, you've sent me a link to the animal rights. Did you want me to bring that on screen?
Yeah, it's just funny because if you want to bring that up and scroll down to where it says strategic litigation, it ties in with the comment you've just had about people using the court for purposes beyond just winning the case. I mean, we obviously like to win the case, but this is actually, because there's a quote just there which I quite like, because I wrote this, although somebody else went through and took all the spelling mistakes out. But actually, I've got to be careful, because I've just realised I called it strategic litigation, which is perhaps not the thing to. When there's the government are going, we need to bring something in to stop strategic litigation. That's call it.
Yeah.
I love this quote. This is actually a quote from Lyndon B. Johnson. I don't know if you can zoom in and see that.
Is it this bit here?
I really believe this.
The law cannot save those who deny it, but neither can the law serve any who do not use it. The history of injustice and inequality is a history of disuse of the law. Yeah, I like that.
Yeah, and my point below is that so often, especially in activism, it's all very reactive. We're used to being arrested. We're used to people bringing injunctions. We're used to people suing us for defamation. But the whole point is there's another side to it, which is private prosecutions, judicial reviews, freedom of information requests, and for your sort of people out there, because you've got an audience that a lot of people are very passionate about causes. Mm-hmm. Don't be afraid to use the law. I mean, there is this idea, especially in certain progressive circles, oh, no, that's the establishment. But, as Dan and I keep trying to stress, yes, obviously the law is part of the establishment, but fundamentally we do try to do justice. Now, the whole thing about it is the law, you go to court to expect justice, what you get is the law. But the law moves towards justice by people pushing it and testing it. And, this is why you've got the roles of juries, and so many criminal offences have either been abolished or amended because juries just wouldn't convict. It's the same in civil law. People push things. Same in judicial review. People test things. People want to test the limits of power and authority in the government. And, whenever you see this thing, government found to have acted unlawfully, judicial review, and I know there's a lot of controversy, but that is how people test the law. And that's how we are a country, supposedly, that operates by rule of law and not just executive whim or powerful one. The law is there, and as we say, like the Savoy Grill, it is open to the rich and poor alike.
Indeed, and I've had many a comment like this, but I certainly had one or two in the last day or two saying that I am part of the system, and therefore I'm only going to support the law, and I'm not going to support the people. And actually, our role is, well, first of all, we don't create the law. That is ultimately to the supreme lawmaking body, which is the Westminster Parliament. And so we don't make the law. I'd say in some sense we have a hand in making the law when we are involved in cases that ultimately make common law, which then interprets what is primary law and how it's applied to a given set of facts and so on and so forth. And so we've got a hand in making the law, but when it comes to us and advising you and giving comments, we don't, as some people think, swear an oath to the state and, above all, we're going to protect the state and so on and so forth. No, quite the contrary, actually. A large part of our job is to challenge the law, to challenge the status quo, to test the boundaries of how the law applies. And it's entirely wrong to say that we are a mere cog of the system or that we work for the system. We are all independent. In fact, one of our primary duties is to remain independent. We've got a set of what we call core duties. And there is what you might expect. There's a duty to the court, there's a duty to the client, there's a duty for confidentiality, there's a duty to be independent. We are all independent, whether we're employed or self-employed or what. We are all independent. So what that ultimately means is, as I stand as legal counsel to my own company, I have to, as a person, as a barrister, I must be independent in that role, in that if I'm providing advice to the company, which is ultimately my company, I still have to be independent. And the advice that I provide has to be independent. In other words, I can't advise it, well, here's how you can get out of doing this, because that's not independent, because there'd be a conflict. So you've got to be independent. So no, we're not just cogs of the system, as some people seem to imply. Absolutely, just found your.
Well, I'll try and lead into this because, ironically, obviously we are part of the system, and we show sort of respect for the office, even if it's not for the people. When it it's like in the army, you salute the office, you salute the rank, not the man, and it's the same thing. And we have all our little silly traditions. And I know you like this. We've got one called dressing the judge, which is a judge should never be left alone in a court. So when your case finishes, unless somebody else is about to suddenly dive into your seat, you're supposed to sit there, and then the judge will say, "Oh, please, Mr. Robertshaw, no need to wait." But it's always a nice thing to do.
Yeah, please don't stay. Exactly, and you just don't get up and leave if the judge is still, and the judge will often say, I'll stay on the bench.
Yeah,
it's a polite way of saying get out.
But exactly. It's like, please don't wait. I've got some paperwork to do, and I can't do that until you leave. But just to say, people say, "Oh, barristers suck up to judges." The one group of people who spend more time than anybody criticising judges is barristers, because we do that every time we draft grounds of appeal. We do it in very nice language. We disagree with it in the same way that judges tend not to use extreme language when they're talking, I prefer the evidence of, or I'm not persuaded by that. Yeah. We do, with respect to the learned judge, we disagree with their interpretation of this. So it's all done in nice, but we are criticising, by definition, we are criticising the judge and their competence every time we stick in grounds of appeal. But it is an issue, and we do get into, not so much these days, because judges aren't allowed to be characters as such, as they used to be, because some judges were complete tyrants. Now they're not meant to be, but the fact of the matter is, to show how often we get into rows with judges, the Bar Council have had to issue guidance about what we deal with judges when we're fought, and it's pretty much don't get into a massive fight with them. It's how we deal with it. Here's how. But the one thing it comes back to in this is guidance about when judicial bullying. It's stand your ground. Remember, you are there to do your job. So long as you are doing your job properly, maintaining your independence, and it says this: maintaining your independence is standing up to judges when they are wrong.
Yeah. And even, to anybody really, but also I think that includes standing up to the solicitor as well, if you think the solicitor is wrong. So in fact, part of our duty is to advise a client if we think the solicitor's given them bad advice or steering them in the wrong direction or whatever it might be. Because again, we are independent, even of those that are essentially instructing us and giving us the work, if it's not direct access, of course. But just looking through some comments here to Dorothy makes a comment about the audio recordings, but I can't. Patricia likes the overall politeness. Yeah, there's always a way of being polite, even if you're. I refer to it as the judicial smile, which is there's an inherent knack of being able to smile when you're giving somebody very strict instructions or directions or a ruling or something like that. I find that quite interesting.
It's like in the military, isn't it? It's like the key to good insubordination is if you just read the transcript, it should sound like somebody was being really respectful.
Yes.
It's all about tone. And this is actually one of the issues that comes in when people appeal on the grounds of sort of, improper judicial conduct. The Court of Appeal recognise that it's difficult because just reading the words doesn't convey the atmosphere. And it is all about, and it says in the guidance about, it says make a note, but try to also record stuff like, judge rolled his eyes, judge, slammed something down on the desk, because that's all the context you need. Because a lot of the time you just read the transcripts and go, that's just a fairly typical argy-bargy back and forth between counsel and the bench.
Absolutely. I'm just going through some comments here. So that was most of what we wanted to talk about, really, wasn't it? Because I
wanted to just bring in, if we have time, because somebody raised a really good point in one of the comments on a previous video, which is just a little bit about costs, and we've mentioned briefly about recovering costs, but I'll try to do this as quickly as possible.
Yeah, sure.
Rule is loser pays winners costs generally. However, costs. Not in America with their American rules, you see. But over here, so loser pays winners costs. However, costs have to be assessed, or to use the old word, taxed, which you sometimes hear some old school lawyers still use. The costs need to be taxed, but it means assessed. Judges can do that in two ways. If the hearing's taken less than a day, each side has submitted their cost schedules. This is what we've spent, and this is what we've spent it on. And a judge will just do a rough and ready calculation. I think that's right. You didn't need to take that long on that. That charge out rate's a bit high. Bang, bang, bang. That's what you get. If, however, it's more complex, they will make an order saying costs to be assessed if not agreed. Now, you'll try and agree them. And one thing that they will do is they'll say, what are your overall costs? You say, well, they're at £100,000. They say, well, even on assessment, they're not going to get. They will get knocked down, but it'd be a really poor day if they went down below 50%. So the other side, pay half of them now, and then you can assess the rest. But costs are assessed on two bases. With the standard basis, every cost you're claiming, every item, it must have been reasonably and necessarily incurred, and the overall cost must be proportional to the action. Okay? And it's for you as the receiving party to prove each of those aspects. You've basically got to fight for every payment you want. However, there's also something called indemnity costs, and indemnity costs are used effectively to punish litigation behaviour. And sometimes they're used to encourage settlement. There are certain types of offers where if you don't agree them and you lose, you have to pay the costs on an indemnity basis. On an indemnity basis, it's still necessary to prove that costs were necessarily reasonably incurred, but it's for the paying party to prove that they weren't reasonably and necessarily incurred, and it's also proportionality goes out the window, so that you can't say, well, overall these costs are too high. So it shifts the burden of disproving the amount to you, and also it basically means even if their lawyers have ripped them off senseless and overcharged them in cost billing, you are picking up the tab for that. On a standard basis, they go, look, lawyers can charge their clients what they want if they're daft enough to pay it, but you shouldn't pick that tab up. But on the indemnity basis, they say, sorry, your conduct in the litigation is such that we're going to say you pick the full bill up. So that's just it. So that's why, like say, on a standard basis, you're looking to get 60, 70% of your costs. On an indemnity basis, you're more likely to sort of be getting into the sort of 80s, 90% of your costs. I mean, some judges, I know one cost judge who said, well, of course, all lawyers only charge for appropriate, reasonable, and necessary work. So assessing on a standard basis should be identical. And then, of course, what you don't see on the transcript is everybody laughing.
Indeed. I just left this on screen, this super chat. Thank you, Trufflehound, if that is your real name, so that Al, you can benefit from the compliment that was Trufflehound's super chat comment here. And just as a note on costs as well, I think I've mentioned before, but on the small claims track in the county court, ordinarily you can't get much more than your issue fee back as the claimant, and the hearing fee, in other words the fixed costs, so you cannot get back your lawyer's fee. So if you pay £3,000-4,000 on a lawyer to fight a small claim, you won't get it back ordinarily. I say ordinarily because, well, two reasons. One, the court always retains overall discretion as to costs, and also there's a little known area of the civil procedure rules which I think we've got time. I might even bring it up. Just bear with me a second.
Part 44. Wow, we're really going into the. We're really going off.
It's actually buried in the small claims track section. If I just stick preview mode on a moment, so I can make sure I've got the right thing being shared, which I don't. So if I switch this screen share to Chrome and make sure it's there. Yes, publish to screen. There we go. Right. So here's our rules for the small claims track, and literally a whole bunch of rules just for the small claim. If you go all the way to the bottom here somewhere, this one here, this is a little known. This is an absolute gold nugget that even lots of lawyers don't know. I've had minor disputes with other lawyers that didn't know this. But under 2714G of the civil procedure rules, on the small claims track, such costs as the court may assess by the summary procedure, as Al just explained, and an order to be paid by the party who has behaved unreasonably. So unreasonably could mean almost anything. It could be that there was a threat made in correspondence. It could be that they blurted out, well, he didn't say that at mediation, or something along those lines, just, attempts to breach privilege. It could be that they thrusted a whole bunch of evidence at the judge on the day of the hearing, say, well, here's all the evidence, and therefore judge might well conclude that they were right on the evidence if the court decides to accept that evidence, because the court can, because the court has the authority, the discretion to control the evidence, of course. But this little rule, for any of those reasons, could mean that the court provides an order for costs, even on the small claims track. It's usually when someone's failed to comply with an order, so they haven't filed their evidence in time, or in one case I had where I believe he actually outright lied to the judge, and he said to the judge, I emailed the evidence to the court 3 weeks ago. The judge says, okay, great, send me the email. He said, what, send you the evidence by email now? He said, and the judge said, no, send me the email that you sent to the court a few weeks ago. Forward it to me. And of course, the elephant in the room was everyone thinking that he didn't send this email 3 weeks ago. He hadn't sent it at all. Was everyone what I suppose everyone was thinking, and I suspect the judge was probably thinking the same. So we waited patiently for about 10 minutes. And this was a trial by telephone during the pandemic and the lockdown. And upon the realization that the judge was going to wait him out and wait for him to forward this email from several weeks ago, which obviously he hadn't sent, he decided his number was up, and he hung up. He just hung up the call. Just hung up on the judge on the trial. And so the judge said to me, right, Mr. Chensmith, what would you like? I said, judgment joint and several against all defendants, please, with costs under 2714G. He said, done. We just got full. And that was piercing the corporate veil as well. There was a company involved. So this was piercing the corporate veil, as if you got a company limited by shares or by guarantee or what have you. The directors of the company and the shareholders are not liable to the claim, beyond that which they've already invested into the company, obviously. But piercing the corporate veil means that the court can say, no, I think the people behind it were personally liable for this, so they can pay. So it was against the company and each of the directors, joint and several, for the full amount with costs. So this little doozy here under 2714G can be very, very useful, because my client got all of their costs back as well. So I thought that was a useful mention.
There's also, if you scroll down to 44.2, which is basically in the general cost thing, which says, effectively, notwithstanding all the rules, the judge can do what they want. Because I use 44.2 quite a lot when I'm trying to either wriggle out of something.
Yeah.
Should I not make the normal order, Mr. Robert Shaw? Well, you don't have to.
I've done exactly the same myself. In fact, my situation was neither myself, opposing counsel, or judge had any idea what costs were to be applicable in this very, very, very particular situation, which was that my client had lost, but actually, in a roundabout way, wasn't really supposed to be part of the proceedings anyway, but had accepted responsibility for them because it was a premises and he was in the premises, and it was an application seeking possession under a commercial tenancy. But he wasn't named on the tenancy. He wasn't part of the tenancy. He could really have responded by saying, "There's nothing to do with me." Albeit it was in the premises, and obviously, it was worthy to at least try to defend it, because he wanted to stay in the property. Of course, there was not supposed to be anything against him anyway. But anyway, so the court in this situation was with no idea what to do in this situation. So we agreed that the court had general discretion, as you say, under 44.2, and then we had an argument about what those costs were supposed to be, given that I was instructed very late in the day and he had accepted liability in the proceedings. Is all very, very complicated, but general discretion is a good one.
I'm just thinking, I don't know if I should disclose this, but you were saying about your friend with email. I had a case very recently where I was complaining about it was something that hadn't made its way in front of the judge, and when we were going through everything, and I said, I sent the email, and I said, and the judge had to point out that I'd spelled judiciary incorrectly in the email address. Yeah, judiciary. I sent it to e-judiciary@gov.uk. Yeah. The judge basically just gave his personal email address.
Yeah.
I like the way, so would it assist? In other words, you're clearly useless and incompetent, just email it directly to me in future. Done.
Yeah.
There were issues about, in my defence, the court was sitting in a different county even to where the court was meant to be sitting, and things had gone astray, and I'd tried to be helpful by emailing PDFs of bundles, but just email them off into the ether.
Yeah. And there's also that momentary panic sometimes when I had clerks relayed an email from a court that I'd been in probably a month or two, close to 3 months beforehand, saying, why wasn't this order drawn? And that's always a bit of a panic thing. I'm sure I did it. The first thing you do is check that you did it. The second thing you do is that you check that you sent it. But initially, there's always that momentary panic of, did I actually do this? And then, as you just said, whether you sent it to the correct address. Because this was 3 separate orders to 3 separate police forces for failing to comply with previous disclosure orders. So it would have been pretty bad had I not drafted and sent the orders as I'd agreed to do so. But I had. It wasn't my fault. I suspect someone else had a telling off that day, but it wasn't me, thankfully. And a court can, interestingly enough, a court can order you as counsel to turn up and explain why you didn't do something if that was the case. And you've got to turn up. You've got to provide a witness statement. You've got to turn up. You might be questioned by the judge. Why didn't you do this? It's never happened to me, thankfully. But there's always that momentary panic when a judge asks, "Where's that order I asked you to do?"
There's a very interesting case recently, actually, and it's all about reliance on the court office. Now, what had happened was somebody had filed a claim they'd filed a claim, and now what they'd done is if you issue a claim in the court, you can actually say to the court, "Can you serve it?" And usually that's the easiest way, because then you'd have to worry with the certificates of service. But you can say, "Can you issue the claim, seal it, send it back, and I'll get it served." Yeah. I'll send a process server out. And that's what they'd done. So they issued the claim, and then they didn't hear anything. And when they went chasing it up, because they were getting very near limitation, the court had lost the file. They said, we can't find the file. So they sent off unsealed claims to the other side, because they were getting very close to the last time they could do it, and said, "Here's the claim. The court office will get the sealed copies to you."
It's been issued and sealed, but yeah.
Yeah, but the court said, and this is what's interesting, the other side challenged on bad service, said that's not service, it's not a sealed claim form. And here's the thing, the court came back and said, no, it's not. And we have no discretion to sort that out. And they said, and here's what's interesting, because this sometimes happens where courts are busy places. You can have a claim struck out because of, and this is where people have been told the wrong thing by the court office or missed a deadline because of what comes over the court. Now, the court said, it's for you, even if you're unrepresented, to get the rules right. The court doesn't give legal advice. So I am striking, so you are struck out. However, you can, when you say we can apply for relief from sanctions, where, something's happened to you, you can say, look, let me off the hook. I've got a good excuse. What that actually is, in that test, relying on the court off what you're told by the court office is a reason to give you relief from sanctions. But unfortunately, for issuing a claim, you can't apply for relief from sanctions, because relief from sanctions is where there's a claim issued, you have been penalised. But before a claim's issued, there's no power of the court to do anything. No. The issuing the claim is the first thing you need to do to get the court involved. And they said the problem is you left it so late before limitation, and also you didn't chase up the court office early enough. Now, personally, I think actually, because sometimes court offices are very busy and you feel guilty ringing them saying, have you processed that? Have we done that? But they had left it for a couple of months, because once you've issued a claim in the court office, you've got 4 months for it to get it served, and they were getting like 3.5 months, and said, "Oh, we better chase this up." And that's it. The court said, "We can't find the file." They accepted they'd had it, but there was no seal, and there wasn't time to redo the. I mean, theoretically, I suppose they could have just sat the court office and said, "Here's copies of all the claims. Can you just seal them, and we'll send those off?" Yeah. But they didn't, and that was a very, very, very valuable claim, and it was struck out merely for that reason. So be very careful.
No, absolutely. There's another strange one with the court office, and this is why I get. I'm sure you do as well. We speak to lots of clients who are very frustrated with what's happened with the court office. Now, let's be fair to the court office. They deal with so much correspondence you've no idea. And as Al said, they're not there to provide legal advice, but that doesn't stop people asking for legal advice. And they only know that it's a request for legal advice when they've read the email, and which they get many thousands. So this is not ragging, as the phrase goes, on the court office. But that said, here's what I'll say about the court office. So in one such case, the rules provide. Let's start with this. The rules provide that a defence has got to be filed and served within a very strict time frame. Initially is 14 days, and if they acknowledge service, they get another 14 days, so 28 days. So in this case, the 14 days had expired. There was no acknowledgement of service, and there was no defence. So the claimant can then request judgment, not apply for judgment. Doesn't need to apply for judgment. Can just request it because they're entitled to judgment. But then the request went unanswered. So he spoke to the court office, and they said, "Oh no, we received a defence on such and such a date," which was after the deadline. So we obviously said, "No, that's outside of the deadline. It wasn't acknowledged, and defence wasn't filed, so it's out of time. We're entitled to judgment." And they said, "Well, no, we go by case law," or words to that effect. It's no, I'm talking about the rules here. This is outside of the rules, and so a whole conversation ensued, and we weren't going to get anywhere. We had to then make an application because the court refused to do anything about it. But it was very clear. It is very clear in the rules. So I empathise with the frustration that it's not just. With all respect, it's not just members of the public that can have difficulties with these things, because the courts are trying to deal with so much all the time that there is this sort of pressing need to just deal with things and sort of get them off the desk, so to speak.
I have to say, though, I'd like to get on record that my local court office and the staff there are absolutely delightful and lovely. All the ones in our local circuit are. And honestly, what I did to get them in terms of here's tins of roses, it would breach the Bribery Act because of all they bend over backwards and they're so harassed and so overworked and systems are breaking at the edges. But they have really, they've done me a lot of favours because this is why you should always be nice to people like that, because I'm not saying they do anything against you, but it's not so much they have discretion, but of course they have a lot of practical influence over what happens. And they've done great things with me, but sort of like there are certain rules about when you can amend things, whether you've got to do an application or not, whether it's been issued. It's like, actually, I've just realised something. Have you issued that claim? Well, have you actually issued that claim? Because I could really do with amending it. And they're going, all right, no, we haven't issued that claim yet. It's still, it's still on the desk. So, and that's all proper and stuff. They are allowed to do that because until it's physically got the stamp on. But and here's a weird thing, right? A rather strange thing is, even though some barristers like myself and Dan are qualified to do what's called practice litigation, so we do what solicitors do, because most barristers aren't allowed to. One thing we're not allowed to do is handle client funds. Mm-hmm. And the BSB take a very strict view of this, and that includes carrying a cheque to the court office. So if we say to the client it's going to cost X £100 for this application or X £1,000 to issue this claim, I'll write you a cheque. No, I can't carry a cheque, apparently. And the other thing is, and I only found out this recently, because what I would do is I would basically, get the client to cover me. But we can't have money on account, you see, even for disbursements. So I would have to go to court and I write a cheque on my own account and I hand that cheque over. But then I have the client on the phone and I say, transfer that money to my account now. If they transfer that money before I hand the cheque over, I breach the rules. But as soon as I've handed the cheque over, I can say, hang on. Pay that money. Yeah, hang on. It's arrived in my account. Yeah, because I've told them if that transfer doesn't come through in like the next 3 minutes, I am asking for that cheque back. But that's it got done for basically getting the client to front the application fee.
And there's obviously the technical rules behind this, and I think I disagree with one of them. And I'm sure if it was ever tested properly, I'd be right. But the technical point behind the check and the issuing, because until the claim is issued, then there's no fee payable, and so if you're given the money first, then you're holding the money before it's due, and it's not client money if the money is not due. So if we agree, even if it's £50,000 a brief on a to run a trial, it's not client money. If it's a fixed fee of £50,000 or even estimated fixed fee or whatever it might be, there's this very, very peculiar rule, which I know at least one barrister who thinks that if it goes to court, it would be overruled and ruled to be wrong. But it's permissible at the moment because this is what the rules say. If I were to say, well, at my hourly rate, I think it's going to be £50,000 to run this to trial. If it's any less, I'll give you the balance back. But in doing so, you must expressly understand and agree that I'm not holding the money on trust for you. Now, with respect, I suspect that a lot of people don't understand what that means. And I think that's a problem. And more importantly, the barrister that I'm talking about think that this is a real problem, because if the person doesn't understand what it means and actually they believe that you are holding it on trust, then it's client money and that breaches the rules. So this barrister thinks that is a serious problem, and that if it goes to court, because most people, we're talking about defamation here, what the reasonable person would infer it to mean, if most people would believe that you're holding it on trust, then it would breach the rules. And so what that means is, if you're holding it on trust, it's a bit like, think of it as lending or asking someone to look after something for you. Let's say if I just say, take this camera and say, hey, Al, hold that for a bit, will you? I'll be back in a minute. But, Al at no point thinks that this belongs to him. It still belongs to me. And even if somehow Al sold it at a great profit or whatever, it still belongs to me. All the profit, everything belongs to me. I'm trusting him with it. And so he's holding it on trust. And the same is true for client money. So when solicitors take money on account, they're holding it in trust in a client account. We can't do that. Fundamentally, we cannot do that. And so this principle of issuing a claim, I mean, if you issue an appeal for a certain amount, I've known, even relatively simple appeals, that the fees to issue the appeal are many, many thousands. And, even issuing a claim, it's £10,000 it can go up to, the issue fee. So, 5% of the claim up to £10,000. So it's a lot of money, but we can't take it from the client until it's issued. So either they pay it themselves. The one thing I disagree with, and I think any judge, if properly had this case before them, would agree that simply having the check in your hand, I think, can't possibly mean you're holding client money, because it's not made out to you. It's not written to you. It's written to someone else. Exactly, I can't cash it.
It's a choice in action, so it's client property. That apparently that's the BSB's view, apparently.
Yeah, I understand that, and I respect it, and I follow it, and we don't, even I had a settlement 3-4 weeks ago now, and as you send them the check. Don't send it to me. Don't send it to me. Send it to them. Because I can't take it.
I'll have to send you a screenshot. I'll just check it's okay. I won't do it on this one. I'll check it where it's a really panicky thing where I sent it by text, iPhone, because the client said it was a massive transaction, and the client said, I've just arranged for it to be paid into your account. And it's literally me by email, text, voicemail.
No.
Do not send it to me.
Yeah, do not. And we have to correct all the time. I will come to the Superchats. I'll see two of them. Trisha, I've got yours on screen. Painfully long for you, but I will come to that in just a second. But what was I going to say? We have to correct emails all the time, where we've had a conversation. I say we, my firm, my chambers, and me personally sometimes have had conversations to agree fees. And let's say it's agreed, I don't know, £1,500 plus VAT or whatever it might be to go and represent them at a hearing. And then they send an email to say, I've put the money on account. That's not what you've done. You've absolutely not put money on account. You've paid a pre-agreed fee, a fixed amount payable fee for the hearing. It's not on account. And there's a fundamental difference between the two. And this is where I say, and this other barrister says, if this were tested properly, the whole refund you thing later on, I think would be difficult. Let's come to these two super chats before we forget. Tricia, thank you for waiting, and thank you for the super chat. Love to know my take on military court martials or courts martial. We called them kangaroo courts when I was serving in the Royal Navy. Well, Al, I think you've got more experience with courts martial than I do.
I used to do lots of courts martial, as the correct terminology is, which is why I like to see that you got it there. And funny enough, actually, you like trivia. The martial in courts martial doesn't come from martial as in terms of the military, like martial arts. It actually does come from that spelling of martial, because before we had a standing army and all the new model army and stuff, the military discipline was under there was a court, the court, the sheriff, the high sheriff and marshal or something, and they had jurisdiction. So that's an interesting one, that. But yeah, we'll have to have a proper, maybe at some stage we'll have to have a proper live stream just about that, because I did it in the old days before they've changed everything now, and the court-martial procedure and the civil courts, it's not that much different. They have like a permanent court-martial centres. Whereas when I did it, every court-martial was done by what we call a convening order. Somebody of appropriate rank would say there is to be a court-martial held at. And they would say where it was going to be. And in practice, you know, we went to a lot of the same regular venues. And I loved it because I won't spoil things, but I had a very good relationship with the court-martial system. And I'll just tell you one thing where I was I think Cosford or somewhere, doing a preliminary hearing in front of what's called a judge advocate. That's like, you know, the judges in the court-martial system. And we sorted all the directions out for a hearing trial that was coming up. And they said, "Oh, any other matters, gentlemen?" And the very nice prosecutor, because you are actually prosecuted by somebody from Army Legal usually, so they're all in their proper nice smart military uniform. And said, "Oh, I'm just waiting." He said, "Well, I'm just waiting for Mr. Robertshaw." I said, "Why?" I said, "I just assumed Mr. Robertshaw would ask for this to be transferred to Bulford Camp." And the judge advocate said, "Well, why would you do that, Mr. Robertshaw?" And I said, "Well, it's just nicer, isn't it?" And the judge advocate said, "Actually, I agree. Yes, let's sit at Bulford." Literally just moved a court-martial across the entire country because it's a much nicer place to be. Because Bulford Camp's right in the middle of Salisbury Plain, and I like walking and archaeology, so that's a really good. And I was once practically resident counsel down there. The court-martial bar is very small, and a lot of the people, they were all doing some Iraq cases. You know, they were all tied up on that. But while they were all tied up on that, people were still getting into punch-ups in the naffy. People were still swiping stuff from stores. And that all needed to be done. So they just listed, because I got a call. The clerk said, "Oh, court-martial people have been on the phone. Can you cover all the cases?" I said, "Well, that's pretty much up to the defendants and the solicitors." But as there were only like really two solicitors who do it anyway, they said, "Oh, that's all right. We've had a word with Gilbert, and they're cool for you to do all their cases." So they paid for me to stop in a pub I really like in Amesbury. And they put me in there, they put the prosecutor in there, and they also gave us like a PA secretary to share. Just like to do all the... And we sat there, we met up beforehand, and we went through all the cases we had coming up, and we did lots of like agreed facts, and we got all the documents together and lists of issues. And we just ploughed through so many. I think on one day we did, one week we did something like 3 district court martials, 2 general court martials, 2 appeals, somebody being brought in by the provost on a warrant for AWOL, and we still took the Wednesday off. I mean, I appreciate what you're saying, and we'll have another talk about the Murray. Because I've got lots to say about this, and I've also got my one successful court-martial appeal courts case that I will want to show if we do this. But I also used to say, if I was innocent, if I was accused of a crime and I was innocent, I would want to be court-martialed. If I was guilty, I'm going to be tried by jury at Snaresbrook.
And just to, so there you have it, courts-martial. And just to pick up Trufflehound, your kind super chat. We always think it's strange when a solicitor wants to pay counsel by check, or anybody by check. Now, we take bank transfers for almost everything, and if someone absolutely can't, then we do have a facility for card payments, but we don't use it very often. We don't like to use it very often. I mean, not only is it hugely expensive these days, but very little protection as well with fraud. I mean, we've had I'm not going to name any particular card company, but we've had cases that have been absolutely slam dunk in our favor, should not be successfully disputed, and the card company says, "Man, we agree." Like, we cannot understand sometimes how these card companies just side with the card holder. We had in our other company, we had somebody who had goods delivered, had signed for those goods, confirmed by email that they'd received those goods, even asked for more in one bit and complained about another bit. Not complained, but just, said, what do I do with this bit, or something to that effect, and asked for more. And then later on, for whatever reason, which I won't go into because it would divulge who it is, but then raised an issue a dispute, like a chargeback with the card company, saying they hadn't received them. And I thought that's utter nonsense. So we disputed it and said, no, here's the signature of delivery, here's the proof of delivery, here's the email where they confirmed they'd received it, and so on and so. And the card company came back and said, no, we agree with them. Utterly crazy. But there you go. So we don't overly trust these card companies anymore.
I've just sent you in the messages, Dan, something. I don't know if you can open the front.
Yeah. Let's take a quick look at this before we wrap up then. This is I
will talk in more about this, because I think it's a really interesting topic that our friend raised there. But I'm only doing this because this is my one successful appeal. And the interesting thing about this is, I've mentioned it before, this is the one that I won because it turned out I was the only person who'd ever read to the end of the Armed Forces Act, including all the schedules. And what's interesting about this is, I always go on about this being my fantastic, one of the few successful appeals in the Court-Martial Appeal Court. But people keep pointing out and go, the prosecution didn't turn up. And they actually say that in the judgment. They go down and say the prosecution couldn't even be bothered turning up.
Yeah.
But yes, that's
there it is.
It's got and it's interesting in judicial language, because there's something in there where they say something like, as to the site visit, locus in quo visit, we don't take, we dismiss that point. Whereas that sounds very neutral. Whereas in court, that was expressed as the purpose of the court-martial system is not to give Mr. Robert Shaw free holidays to Akrotiri. So, which showed we were operating on a very different understanding of how courts-martial were meant to work. We do not accept that.
I think it's that bit there.
And what's interesting, they get back anonymity. That was actually a really good point about unanimity. Now, this actually does tie in. Maybe I'll just stop rambling after this one point. The way they do verdicts in court, a court-martial doesn't have a jury. It has what they call a board. Mm-hmm. But the board consists of, depending on the seriousness of the case, a number of 3 to 5 to sometimes 7
senior officers.
Members, not non-legally trained people, just members of the armed forces. But also the judge advocate, who is also the judge in the trial, sits with them and is effectively on the jury. But what they do is, when they take a verdict, they pull in reverse order of seniority. So, if you're the private, you go first, then the corporal, then the sergeant, all the way up through the officers to the judge. And the idea for that is so that nobody will feel pressured, because effectively if the senior officer goes, well, I think he did it, and you're some private, you're not going to go, I disagree. So they actually go round. But the point is, if there's a majority verdict, it operates the same as in the civil court, and they say, well, we've taken a vote, we can't agree. And they say, well, go back again. But my argument was, well, by that stage, they've all heard what each other is saying. So when they do the unanimity, if the majority was the private and the colonel said, I think not guilty, everybody else said guilty. All right, let's go around again. Now me, as your boss, thinks he's guilty. Would you like to reconsider your vote? So I actually think it wasn't that bad a point, the unanimity point. But I think there was just the practicalities. They're basically saying what you're arguing is every time there's a hung jury, it's a mistrial. You're saying we can't pull them again. And I went, well, yeah. And when I said that, I went, that's clearly not as good a point as it sounded like when I wrote it.
Fascinating. Yeah, and I think as the comments just requested, we should do a whole session on this. But there it is. We have, I believe, successfully delivered on the what would otherwise be clickbait thumbnail. But no, we've delivered on that and more, I hope, for an hour and a half. So thank you all for your kind attention. I hope that was informative, useful, entertaining, and all the above. And thank you for your attention. And thank you, Al, for joining us once again.
Thank you for having me. And thank you for all the very interesting comments and questions, because that really helps knowing what you might want to hear about.
Absolutely, it does. We will be back. And as for my recent community post, I'm going to be doing a Q&A, bit of a Q&A. You can direct some of those questions at Al as well if you wish on that post. Check that out. And I'm sure Al wouldn't mind pre-recording some of the answers to those as well. And so yeah, check out for that. That will be going up on Black Belt Secrets as well. So that's been linked by our fantastic and famous secret, Mug Squirrel. Go and sign up over on Black Belt Secrets. And that's where the Q&A video is going to be going. So with that, I thank you all for your really wonderful comments of thanks in the chat box. It's always heartwarming to see all those. Thank you for your attention. I hope you enjoyed that, and we'll be back and we will see you next time.